Hey guys, in this video, we're going to talk about the recent U.S. Supreme Court decision that impacts visa revocations. Stick around all the way until the end. We're going to cover the facts of the case. I'm also going to share with you facts of a case that we worked on that are incredibly similar to the case that went all the way up to the U.S. Supreme Court, but thankfully we were able to win our case. I'm Latoya McBean Pompy, an immigration lawyer in New York, working with clients globally at McBean Law. Reach out to us, guys, so that we could take a look at your case to see how we might be able to assist you. Now, let's talk about the case. The U.S. citizen wife filed for her husband, and her I-130 petition was approved. But 2 years later, USCIS sent a notice of intent to revoke the approved I-130 visa petition. Why? It was alleged that he was part of a marriage fraud or sham marriage. How did they come to this conclusion? Well, they interrogated his ex-wife. During the interrogation of his ex-wife, she admitted to the fact that he paid her $5,000 and she only entered into this marriage for the money. So USCIS revoked the I-130 approval. After that happened, they filed an appeal. It went to the Board of Immigration Appeals, and the board said, we agree with USCIS, because apparently the I-130 was approved in error. Then after BIA made its decision, they took the case outside of the immigration system into the federal district court. The district court dismissed the action. They didn't see anything wrong with what USCIS did. And in fact, they said, we are not even supposed to review this because this is not under or within our jurisdiction. After that denial, they went ahead and appealed the decision to the 11th Circuit Court of Appeals. And the 11th Circuit said there is no jurisdiction for the federal courts to review a case like this one because it is a discretionary issue that the Department of Homeland Security maintains, and they have that ability to make a decision like revoking an approved I-130 petition. After the 11th Circuit made that decision, they took the case all the way up to the U.S. Supreme Court, which also agreed with the lower courts and said that DHS has the discretion to make a decision on these I-130 revocation cases. It falls within their discretion, and therefore federal courts aren't allowed to review these types of decisions. Now, you might be saying, but wait a minute, what are they supposed to do then? Because the U.S. Supreme Court made this decision. Are they stuck? Is it over for them? And the answer is actually no. And I read the decision. It was a unanimous decision by the court, written by Justice Jackson. And in the opinion, she also mentioned the fact that this couple still has remedies under our law to pursue, including the fact that the wife filed another I-130 petition for her husband, and that petition is still pending. With the evidence that the wife is showing USCIS, it's possible for them to approve her I-130 despite the fact that the case has been revoked. Now, here's the thing. If USCIS denies the second I-130, they can take that denied I-130 into the federal court system for a federal judge to review that decision. The distinction here is that with visa revocations or the I-130 revocation process, it's completely discretionary, and the federal courts do not have the right to review those types of discretionary decisions, but they can in fact review a denial, which can also be based on their discretion too. It's very nuanced. It's a complicated issue, but the bottom line is that it's possible for them to still get through despite having all of these problems with the court. Here's what's also interesting about this case. The U.S. citizen wife presented evidence that the ex-wife recanted her statements. The ex-wife said that she only made those statements because she was under duress and that it was not a sham marriage. Nevertheless, whatever evidence was submitted showing that she recanted, it didn't work, and the case went all the way up to the U.S. Supreme Court. Like I said earlier, guys, We had a success story in 2023 with facts exactly like this case involving our client from Morocco who met with us in 2021. With the reason why he and his wife met with us is because he was on his third marriage to his U.S. citizen wife. She filed for him and her I-130 was approved. And then years later, USCIS revoked her approved I-130. She then filed again. The case was denied and they appealed the decision. The reason why USCIS revoked the I-130 is because they alleged that he was involved in a sham marriage to one of his previous U.S. citizen wives who had filed for him. When we started his case, we recommended that we file a new I-130 for them, despite the fact that they had an I-130 on appeal. We presented very, very strong evidence to prove that he was not part of a sham marriage. USCIS agreed with us, guys, and his I-130 was approved. After 10 years of battling USCIS on this issue of the I-130 revocation, they finally got the victory and he is now eligible for adjustment of status. Guys, do not lose heart because this Supreme Court decision is negative. Despite this decision, it is still possible to take a denied case to federal court. It's just that these visa revocation cases cannot be reviewed in federal court. I hope you found this video helpful. Comment below, let me know your thoughts. Also, before you go today, don't forget to subscribe to my channel and hit that notification bell so that you'll be the first to get my updates each week. Thanks so much, guys, for being with me in 2024. I very much enjoyed being part of your journey this year. I wish you guys a wonderful holiday and a prosperous and healthy new year. See you soon. Bye-bye.